Hello, everyone, and welcome back to the Workplace Compass VWV Employment Law Podcast. I'm Jess. I'm a legal director and knowledge lawyer in the employment team here at VWV.
And I'm Nick, a partner in the employment team.
So in this episode, we're going to provide an update on where the Employment Rights Bill has now got to. It's gone through another intense round of parliamentary ping pong this week between the House of Commons and the House of Lords.
Yeah, most of the outstanding disagreements between the two houses have now been resolved, but there is one significant issue still in play, and that is the proposed removal of the statutory cap on compensatory awards for unfair dismissal.
Yeah, that's right. So we'll start by briefly summarising the areas where agreement has been reached, and then we will spend a little bit more time unpacking what's turned out to be a bit of controversy around the removal of the compensatory award cap. We will look at what is going to happen next. So before we get going, just to say this episode is part of our Workplace Compass series, and Workplace Compass is our dedicated resource which is intended to help employers navigate the significant programme of employment law reform now underway in the Employment Rights Bill and indeed beyond. So if you haven't already, please like and subscribe so that you don't miss any future episodes.
So starting with the good news, a number of the remaining points of disagreement between the Commons and the Lords were settled on Wednesday, the 10th of December. First, guaranteed hours offers for 0 hours and low hours workers. The agreed position now places a statutory duty on the government to consult before setting the detail in regulations, including the length of the reference periods. That consultation duty applies both to directly engaged workers and agency workers.
Yep, and then secondly, seasonal work. So the Lords had been pushing for a statutory definition of seasonal work for the guaranteed hours offer provisions of the bill, and the government were resisting that. And the compromise is that there's going to be a statutory duty to consult with representatives of seasonal workers and also of employers before the regulations are made to bring those provisions into force. So that means that the impact on genuinely seasonal sectors should at least be considered before the guaranteed hours offer regime is finalised.
Then there's the topic of trade union political funds. This is about how trade union members contribute to a union's political fund, which is used to support political campaigning and related activities. Under the current rules, which were introduced in 2016, new union members must actively opt in if they want part of their subscription to go towards the political fund. The Employment Rights Bill reverses that position, which gets us back to the pre-2016 model, under which members are automatically included in the political fund unless they choose to opt out. That change is now settled. However, amendments agreed this week clarify how and when opt-out notices take effect, including giving unions more flexibility over timing, and they place a duty on the Secretary of State to publish guidance within 3 months of the provisions coming into force. The intention is to make the opt-out process clearer in practice while still delivering the government's policy of reversing the 2016 opt-in requirement.
Yeah, that's right, Nick. And then we do also now have a settled position on industrial action ballot turnout thresholds. So the 50% turnout threshold, which again was one of the hotly contested elements of the bill, that's now not going to be removed immediately. So instead, the government is under now a duty to consider the impact of electronic balloting on turnout, and it's going to have to lay a statement before Parliament before deciding whether to remove the threshold. So essentially, they will wait for the impact of electronic balloting to be a little more obvious, a little more established before making further changes. And electronic balloting itself is expected to be introduced by April of 2026.
Yeah, and finally, there's the unfair dismissal qualifying periods. So as we discussed in our last episode, the government has now conceded a 6-month qualifying period rather than day one rights. and has agreed that this can only be changed by primary legislation.
Yeah, absolutely. So all of this leaves us then with just one unresolved issue, and that is the proposal to remove the statutory cap on compensatory awards for ordinary unfair dismissal claims. So as a reminder, the compensatory award is currently capped at the lower of 52 weeks pay or the statutory maximum, which is currently just over £118,000.
Yeah, and the government's amendment would remove both elements of that cap entirely. That would be a significant policy change and has attracted criticism on two main grounds. The first is a procedural criticism. The proposal was introduced very late in the bill's passage through Parliament at the ping pong stage, without prior consultation and without an impact assessment and without having been debated during earlier stages of the bill.
Yeah, and the House of Lords was particularly concerned about that point, and actually on Wednesday, peers from across the House described it as constitutionally troubling to be introducing such a major change at such a late stage of the bill, especially when previous changes to unfair dismissal compensation limits have been preceded by consultation.
Yeah. The second criticism relates to confusion over what was actually agreed in the room during the negotiations between the government, business representative organisations and trade unions. The government's position is that removal of the cap was discussed and agreed in those meetings. Some employer groups, though, have publicly said that they understood that lifting the cap meant reforming or increasing it, not abolishing it altogether, and that this distinction was not clearly signalled at the time.
Yeah, and that ambiguity has clearly fueled quite a lot of unease, I think it's fair to say, particularly amongst employers and SMEs who are really concerned about the potential exposure that leads from the complete removal of the cap on the compensatory awards and the way this change has been brought forward.
Yeah. The government has responded to those concerns and has said that it will publish an enactment impact assessment after Royal Assent, but before the commencement regulations for the unfair dismissal reforms are laid.
Yeah, and that impact assessment, they say, is going to specifically cover the removal of the compensatory award cap. And the government did also say this week that it's going to engage further with business groups and that the issue is going to be considered as part of its wider work on the capacity and resilience of the employment tribunal system.
What the government hasn't done, however, is agree to delay or condition the removal of the cap itself. The Lords passed an amendment requiring a formal review before abolition, but the Commons has not accepted that approach so far.
Yeah, so where does all of this leave us then in terms of next steps? Well, the House of Commons is going to consider the Lords' latest amendments on this Monday, 15th of December. That's just going to be a formality. The Commons has already published its motions in advance of Monday and it hasn't made any concessions, and so its position hasn't changed in respect of the compensatory cap. So the motions are simply confirming that the Commons disagrees with the Lords' amendment, and that's as far as they go.
And that means that the bill will be sent back to the House of Lords for them to think again. The Lords are expected to sit later next week, with the Christmas recess beginning on the 18th of December, on next Thursday.
So it is worth noting that the Lords' vote on Wednesday was lost by a really narrow margin this time, so only around 20 votes in it. So the question now is whether the government, as I'm sure it is, hoping that by holding firm and sending the bill back one last time, that will be enough to get it through. And the question is, of course, whether it in fact will be, and whether we will see Royal Assent this side of Christmas.
Yeah, if the Lords don't back down, the bill does risk running out of parliamentary time before the recess. That would delay Royal Assent and potentially push back key implementation dates.
Yeah. So from an employer's perspective, then the key takeaway at this stage is that most of the big ticket issues are now settled, but the position on unfair dismissal compensation does remain outstanding between the two houses. And of course, you know, the way it's been raised has led to concerns about process and clarity, and there are also concerns about the impact of the removal of the cap as well.
Yeah, so we'll be watching very closely to see whether the Lords ultimately concede or whether this final issue forces the bill into the new year.
And as always, we'll continue to update you as things develop.
That brings us to the end of this episode of Workplace Compass.
If you found this episode helpful, please like and subscribe, and do explore our wider employment rights bill resources. Bye for now.
Thanks, everyone. Cheerio.